Judgment in the appeal, Mark Lundy and the Queen.
On the morning of the 30th of August 2000, a 7-year-old girl called Amber Lundy and her mother, Christine, were found murdered in their home in Palmerston North, New Zealand. Some days later, Mark Lundy, Christine's husband and the father of Amber, was charged with their murders. He was tried before Mr. Justice Ellis and a jury at Palmerston North High Court in 2002. He was convicted of both murders. He appealed against those convictions, but his appeal was dismissed by the New Zealand Court of Appeal on the 13th of August 2002. Mr. Lundy claimed that he could not have committed the murders because he was many miles away at the time which the Crown suggested they had been committed. The evidence against him fell into three main categories. First, analysis of a small area of staining from a polo shirt worn by Mr. Lundy was said to contain central nervous system tissue from Mrs. Lundy. Secondly, the post-mortem examination of the stomach contents of Mrs. Lundy and Amber suggested that their deaths were likely to have occurred between 7 and 7:15 p.m. on the 29th of August, and it was claimed that it was possible for Mr. Lundy to have driven from Petone, where he had been on the evening of the 29th of August, to have committed the murders and returned to Petone in order to fabricate an alibi. Finally, it was suggested that a computer in the Lundy home had been tampered with in order to make it appear that it had been switched off by Mrs. Lundy at 10:52 p.m. on the 29th of August, when Mr. Lundy was many miles away from the matrimonial home. It appears that after the Court of Appeal had delivered its judgment, Mark Lundy informed his legal advisers that he wished to appeal to this board. Difficulties in funding an appeal, the lack of legal aid, and problems associated with persuading counsel to act pro bono combined to prevent an application for permission to appeal being made until November 2012. A permission was sought on 7 grounds. These included a challenge to the Crown's expert evidence that had been given at the trial. That challenge was based on new evidence which the appellant sought to have received on the appeal. That new evidence disputed each of the areas of scientific evidence on which the Crown had relied on trial. The first issue that the board had to deal with was the question of jurisdiction. Since the 1st of January 2004, appeals from decisions of the Court of Appeal in New Zealand lie to the New Zealand Supreme Court. But the jurisdiction of the Judicial Committee of the Privy Council to hear appeals from decisions of the New Zealand Court of Appeal, which had been reached before the 1st of January 2004, has been preserved. Of course, it was necessary to consider the reasons that an application for leave had not been made before, and whether permission should be given when it was open to Mr. Lundy to apply for the royal prerogative of mercy. For reasons that the board explains in its judgment, it decided that these circumstances should not prevent Mr. Lundy from being given permission to appeal. On the hearing of the appeal, the new evidence was considered in great detail. The board considered that that evidence was credible, although, of course, it reached no conclusion as to whether it would be preferred to that of the Crown's witnesses. The new evidence was not fresh in that it could have been obtained for the trial, but the board decided that since it presented a direct and plausible challenge to the central elements of the prosecution case, the interests of justice demanded that it should be admitted. The board then had to decide whether Mr. Lundy's convictions were safe, given the evidence emerging after trial. The test in New Zealand, as in the United Kingdom, as to whether a conviction is safe in these circumstances is whether the new evidence might reasonably have led to an acquittal. On that basis, the board holds that, in light of the new evidence, Mr. Lundy's convictions could not be considered safe. Since the trial, a substantial body of evidence from reputable consultants has cast doubt on the methods the Crown had relied on to establish the time of death based on the post-mortem examination of the victims. Furthermore, the use of the particular method used to identify the tissue as central nervous system tissue is controversial, both in criminal trials generally, because it is relatively untested in that context, and in the particular circumstances of this case, where there is at least reason to doubt the accuracy of the testing, given the state of the samples. Finally, evidence produced by the appellant suggested that the tampering to the computer had an innocent explanation, in that it had been caused by a virus which had not been detected by the Crown's witness. Having concluded that the conviction should be quashed, the board considers that the best course is to remit the case to the High Court rather than to the Court of Appeal, because the divisions between the experts are so profound, they range over so many areas, and they relate to matters which are so central to the guilt or innocence of the appellant that they may only properly be resolved by the triers of fact in a trial, where a suitable and searching inquiry into all these areas of dispute may take place. The board will therefore humbly advise Her Majesty that the appeal should be allowed, that the convictions should be quashed, and that the appellant should stand trial again on the charges of murder as soon as that can be conveniently arranged. The appellant should remain in custody pending retrial, subject, of course, to any decision that the High Court of New Zealand might make on an application for bail. Court is now adjourned.